All right, we've got this breaking news just coming into our newsroom right now. The Supreme Court has issued a ruling.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
This is a case that's been bounced around back and forth throughout the court system.
The Ninth Circuit upheld California's ban on magazines that hold more than 10 rounds.
Imagine waking up one morning to discover that a law affecting millions of citizens, a law that seemed permanent, untouchable, backed by years of political momentum, had just been struck down, not by Congress, not by a governor, but by a court decision so powerful it could trigger a cascade of changes from coast to coast. That's exactly what happened when the Ninth Circuit Court of Appeals, historically one of the least friendly courts to gun owners, issued a ruling that sent shockwaves through every state house in America. This isn't about politics or partisan talking points. This is about a constitutional earthquake that's already reshaping the legal landscape, and most people have no idea it's happening. For decades, certain states told their citizens that limiting magazine capacity would make everyone safer. The magic number was 10 rounds, allegedly enough for self-defense, but not too much for comfort. California led the charge, transforming this concept from policy proposal into criminal law. By 2016, simply possessing a magazine holding more than 10 rounds could land law-abiding Californians in serious legal trouble. Millions of citizens faced an impossible choice: surrender legally purchased property, destroy it, or risk becoming criminals overnight. The state's message was clear and uncompromising: comply or face consequences. But here's what makes this story fascinating. The magazines being banned weren't exotic military equipment or specialized tactical gear. They were the standard configuration for America's most common firearms. A Glock 17 comes with 17 rounds from the factory. An AR-15 typically holds 30. Most modern pistols ship with magazines containing 12 to 19 rounds. Calling these high capacity was linguistic sleight of hand, rebranding the ordinary as extraordinary to justify restriction. The term itself was a political construction, not a reflection of what manufacturers, gun owners, or even most law enforcement considered normal. Then came 2019, and something unexpected happened. Judge Roger Benitez of the Southern District of California issued a ruling that stunned observers on both sides of the debate. He declared California's magazine ban unconstitutional, stating plainly that banning magazines in common use violated the Second Amendment. The result was something gun owners would later call Freedom Week, a brief 7-day window when Californians could legally purchase, sell, and import standard capacity magazines without restriction. The response was extraordinary. Gun shops across the state sold out within hours. Online retailers shipped tens of thousands of magazines to California addresses. Conservative estimates suggest over 1 million magazines entered the state during that single week. And here's the detail that matters most: nothing catastrophic happened. Crime didn't explode. Emergency rooms weren't overwhelmed. The dire predictions that had justified the ban in the first place simply didn't materialize. Freedom Week demonstrated that ordinary citizens wanted access to equipment the rest of America already owned freely, and that access alone didn't create the dangers politicians had warned about for years. The legal framework undergirding these restrictions fundamentally changed in 2022 with a Supreme Court decision called Bruen. Before this ruling, courts evaluated gun laws using what's called a balancing test, essentially weighing the government's interest in public safety against individual rights. Under this framework, states could justify almost any restriction by arguing it served safety purposes, and judges typically deferred to those arguments. Bruen demolished this approach entirely, replacing it with a new standard: text, history, and tradition. Under this test, laws must be rooted in the Second Amendment's original meaning or demonstrate clear historical precedent. Safety arguments alone no longer suffice. When you apply this new standard honestly to magazine capacity restrictions, the laws begin to crumble. There is no historical precedent for limiting ammunition capacity. The founders intended citizens to possess effective weapons, and the underlying principle was straightforward: the people should not be outgunned by those who might threaten them. Colonial Americans owned the same firearms as military forces of their era. The idea that government could dictate how much ammunition a citizen could load into their weapon would have been alien and alarming to those who drafted the Bill of Rights. With Bruen establishing the new legal framework, the California case, Duncan versus Bonta, returned to the Ninth Circuit with renewed significance. Plaintiffs argued that the magazine ban could not possibly survive under the new constitutional standard. What happened next shocked legal observers across the country. The Ninth Circuit, long considered one of the most hostile venues for Second Amendment claims, struck down California's ban. The court admitted that magazines in common use are constitutionally protected arms. They recognized that the state's safety arguments didn't hold up under the new rule established by the Supreme Court. This wasn't simply another incremental legal victory in a long-running battle. This was the first major Second Amendment win in the Ninth Circuit in recent memory. If even this court, in this jurisdiction, couldn't uphold California's restriction, similar bans across the country suddenly looked vulnerable. The implications extended far beyond one state's borders. Understanding why this matters requires looking beyond abstract legal theory to real-world scenarios. Gun control advocates frame magazine capacity as a matter of preference or convenience, arguing that 10 rounds should be sufficient for any legitimate self-defense situation. But this framing ignores brutal realities that courts are now being forced to confront. Consider the mathematics of defensive encounters. Multiple attackers are common in home invasions, carjackings, and gang-related violence. These aren't hypothetical scenarios. They're documented patterns in crime data nationwide. 10 rounds can be expended in seconds when facing multiple threats. And here's a critical detail that rarely enters public debate. If 10 rounds were genuinely adequate, why do law enforcement officers routinely carry firearms with 15 to 17 rounds plus spare magazines on their belts? If the state's own armed agents require more capacity to protect themselves, how can that same state argue citizens need less to protect their families? Stress drastically reduces accuracy in life-threatening situations. Even extensively trained shooters miss under pressure. Studies of police-involved shootings show accuracy rates often drop below 25% in actual gunfights. That means a defender might need 4 shots to stop one threat, not because of poor training, but because human performance degrades under mortal stress. If you face 3 attackers and your accuracy drops to 25%, simple arithmetic reveals the problem. 10 rounds becomes woefully inadequate, and reloading in the middle of a life-or-death encounter isn't merely difficult, it could be fatal. Real cases illustrate these principles with stark clarity. In Houston, a homeowner was startled awake by 4 armed intruders breaking down his door. In that chaotic moment, dark, terrifying, adrenaline surging, he grabbed his firearm and defended himself. He fired more than 10 rounds during that encounter. If he'd been restricted to California's 10-round standard, he would have been forced to reload while under attack. That pause, even 2 or 3 seconds, could easily have cost him his life. This isn't an isolated incident. Defensive gun uses frequently involve exactly these conditions: multiple attackers working together, high-stress environments where accuracy plummets, and limited time windows where reloading simply isn't an option. California predictably refused to accept defeat. When courts struck down the magazine ban, state lawmakers immediately launched a counteroffensive. Their strategy shifted from outright prohibition to what critics call death by 1,000 cuts, burying gun owners under endless new restrictions that achieve through complexity what they couldn't accomplish through direct bans. They've declared more and more locations as sensitive places where carrying is prohibited. They've proposed mandatory liability insurance requirements before citizens can exercise constitutional rights. They've expanded training requirements, paperwork, and renewal fees that transform a right into an expensive, time-consuming privilege. They've passed emergency measures designed to slow and confuse gun owners, even while lawsuits proceed through courts. But here's what makes the current moment so significant. These new schemes lack historical precedent just as surely as the magazine ban did. There's no founding-era tradition of banning firearms carry across entire cities or demanding citizens purchase insurance to own weapons. That's why these new restrictions are already facing legal challenges, and why courts applying the Bruin standard may strike them down just as they did the magazine restriction. The impact of Duncan versus Bonta is already spreading beyond California's borders like legal contagion. Once one court strikes down a particular type of restriction, other courts are forced to re-examine similar laws in their jurisdictions. Precedent creates momentum. New York's SAFE Act includes a 10-round magazine capacity limit that's now facing lawsuits using Duncan as direct precedent. New Jersey's 10-round cap is under similar challenge. Hawaii, which falls within the Ninth Circuit's jurisdiction, could see its restrictions collapse without requiring separate litigation. Illinois recently passed sweeping restrictions on both rifles and magazines that are now being challenged using Duncan's reasoning. This matters because legal victories create cascading effects. When courts in multiple states begin striking down similar bans, momentum builds that even higher courts cannot easily ignore. And when the Supreme Court eventually weighs in, which seems increasingly likely, the resulting standard becomes binding nationwide. What began as a California fight is rapidly becoming a national transformation of Second Amendment jurisprudence. The political ramifications are already evident in Washington. Gun control advocates warn that striking down magazine bans endangers public safety and are pushing federal legislation to replace state laws. Second Amendment advocacy organizations celebrate Duncan as vindication, calling it proof that courts are finally taking constitutional protections seriously. The White House finds itself trapped between political commitments and constitutional reality, publicly denouncing the decision while privately understanding that another Supreme Court case could deliver an even more comprehensive defeat. Election strategists already recognize that Duncan will shape upcoming campaigns, forcing candidates to take clear positions on questions they might prefer to avoid. For gun owners, Duncan represents both victory and warning. The ruling proves that persistence and legal strategy work, that constitutional rights can be reclaimed through sustained effort in courts. But it also demonstrates that opposition never quits. States will continue inventing new restrictions, disguising limitations as safety measures, and testing the boundaries of what courts will tolerate. Staying informed about ongoing litigation, understanding rights under current precedent, supporting organizations funding these expensive legal battles, remaining politically active, and educating others with accurate information, all of these remain essential. Duncan versus Bonta now stands alongside other landmark Second Amendment rulings. Heller in 2008 confirmed the individual right to own firearms. McDonald in 2010 applied that right against state governments. Bruen in 2022 confirmed the right to carry outside the home. Duncan in 2025 secured the right to own standard capacity magazines as protected arms. Each decision built upon previous foundations, gradually reconstructing constitutional protections that had eroded over decades. The question now is whether Duncan represents the final chapter in magazine ban litigation, or merely the opening act in a much broader constitutional reset. Magazine bans are falling, but states are simultaneously creating new obstacles. Courts are shifting toward protecting rights more robustly, but resistance in certain jurisdictions will prolong battles. Each victory sparks additional lawsuits targeting other restrictions, rifle bans, waiting periods, licensing schemes that may prove equally vulnerable under the new legal standard. This is more than a gun rights story. It's a case study in how constitutional protections can be eroded through incremental restriction, how courts can either defend or defer on fundamental rights, and how persistent legal challenges can eventually restore what seemed permanently lost. Duncan versus Bonta may ultimately be remembered as the catalyst that triggered a comprehensive reevaluation of firearms regulations nationwide. Whether that happens depends on continued legal pressure, political engagement, and public understanding of what's actually at stake in these debates. The fight isn't over, it's evolving. And what happens next will shape Second Amendment jurisprudence for generations.